Welcome everyone. I think since we have a small group, we could maybe have you all introduce yourselves and share any information on where you work or what you're thinking about or what brought you here. Although be mindful that this is not a confidential space, so it's probably not a good idea to share any sensitive details about, oh crap, I think we're in trouble because of blah blah blah. But feel free to share whatever you want to share about what you're thinking about or what workplace you're at. If you would like to share, it might help us know how to kind of focus our talk a little bit.
And just as a reminder, you are being recorded, just your voices, not your lipstick.
Oh, okay.
And we'll put it on.
I had this lipstick on.
I know,
would you like to start?
Sure, if you want to pick on me first, I'll go. I'm Galen Logan. I'm the founder and director of an agency called Village Connect. And I'm here because we depend a lot on contract workers. And our board is freaking out a little bit, just really around what that means in terms of the changes and what we need to do to keep our operation going. Good to be here. Thank you.
Welcome. I'm Cami. I go by they, them, and I am trying to. Well, I'm in a master's for Cooperatives, and I'm trying to start my own worker co-op in the form of a tutoring company. I am a student right now, so very beginning stages, but trying to learn as much as I can about what affects co-op.
I'm Stuart. I run a window cleaning, pressure washing, gutter cleaning business. Been in business 30 years. It's a corporation. So I have employees and I have some contractors or subcontractors. Some of them are involved in work that it's a primary part of our business. Some of them are doing other work that we don't do, such as painting, things that are not core to our business. And so I'm looking at this whole 85 thing. It seems like some of the people that I have are they're individuals, and others I'm using as companies. Their insurance and everything. So.
Thank you so much for introducing yourself.
Yeah. So I'm going to get started with a presentation overview, and again, since it's a small group, we can be a little bit flexible about this presentation that we prepared here.
We have one more person.
I was just about to get started, but since it's a small group, I've been inviting folks who want to introduce themselves to the group to tell us your name and a little bit about where you work or why you're here, but it's not a confidential space, so don't share any sensitive details that you might be concerned about sharing in a more public setting.
Okay, thank you for that. So I'm Victoria. I use she, her pronouns, and I work at Design Action Collective just down the street. We're a worker-owned co-op, and I'm just here to learn more about how this law affects co-ops, basically.
Cool. Great. So we're going to start with some really simple definitions of terms like employee and contractor, and then we'll get into a lot more nuance later, but we're going to start with the basics. I'm going to provide a little bit of political context to AB 5, which is the new law that's been in the news a lot. You've probably heard about it. And a little bit of the sort of background on a Supreme Court ruling that kind of led up to where we're at now, and we're going to explain the ABC test, which is out of that court ruling and kind of part of the new legislation that's been in the news a lot.
That's a quick question.
Yeah.
Will this PowerPoint be available to us?
We can share it. If Tia, do you have the contact info for people who registered?
Yes, but reminder that I'll ask everyone to sign in.
Sweet.
And also we will upload the video to the website, and the video will have
Just blank.
Okay.
Awesome. And
then I will go into, an introduction around AB5, what it is, compare it to the umbrella test with the ABC test, and then we're going to go through the exemptions to AB5. Just FYI, we're going to go through, different tests and factors. If you get confused, please, at any time during this presentation, raise your hand and let us know, and we'll be happy to clarify.
And then Hasmeet will talk about we'll both discuss some of the exemptions to the new, AB5 law. So getting started, you have all probably heard, these words, employee and contractor, or sometimes the phrase independent contractor or 1099 contractor. Those are all, I may use those words interchangeably more or less. And in the law, there's a really significant distinction between these two terms, becoming an even more significant distinction. But usually an employee works for a wage or a salary for somebody else. A contractor is usually a person, or it can be some sort of a corporation or other enterprise that undertakes a contract, usually a written contract, to provide materials or labor, and usually they perform work by the job, not necessarily as under a sort of indefinite salary or wage. That's sort of the very broad, generic distinction between employee and contractor. And under federal law and under California law, employees have a lot of rights to get things like minimum wage and extra pay for overtime work and meal breaks, and there are lots of rights that employees have. And so I think you all are familiar with the, common practice to want, for employers to want to treat certain workers as contractors instead of employees, because employees have a lot more things that they're entitled to, which tend to cost more money for employers. And so, we'll get into more nuance about the kind of new distinctions between these terms. But just want to make it clear, this is what we're talking about, the difference between employee and a contractor here. And that's what this is all about. And some political context to AB5, which is the new law that we'll be talking about. You all have probably seen or heard news headlines like a lot of these up here on the screen about the gig economy choking the middle class or destroying the middle class, about Uber and Lyft drivers not even earning minimum wage, and a lot of these kind of issues in the gig economy, which has sort of exacerbated this misclassification of workers as independent contractors. So it's, the employee versus independent contractor sort of controversy has existed for many, many years, but it's a lot of these gig economy technology platforms really sort of driving a lot of the recent controversy that has led to some of the court rulings that we'll be talking about, and to the most recent legislation, Assembly Bill 5. And kind of the need to address these issues. And so, before we had the recent legislation that we'll talk a little bit more about later, I think it's helpful to understand this landmark court ruling that came out of the California Supreme Court back in 2018. It was called Dynomax Operations West, Inc. versus Superior Court. It involved this company, Dynomax, that does a lot of deliveries and distribution of goods for their clients, and they were classifying many of their delivery truck drivers as independent contractors, not as employees. The Supreme Court, the California Supreme Court in this case, ultimately ruled that those workers were misclassified and that they should have been treated as employees, not as independent contractors. And this ruling is so significant because it upheld this kind of stricter standard for determining who can be, an independent contractor instead of an employee, and that's called the ABC test. And so the ABC test is a 3-part test, A, B, and C. So, I'll go over that. Part A is that, if you want to, if a company such as Dynomax, this, big delivery company, wants to treat a worker as an independent contractor, if a company wants to evade employment laws, basically, the company has to show that the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract and any kind of written contract and in fact. So you can't have like a written contract that says the worker gets to set their own hours and work at their own pace, but in reality has a boss kind of cracking the whip. Part B, in order to treat a worker as an independent contractor, the worker performs work that is outside the usual course of the hiring entity's business. So this is really unfavorable to the Dynomax situation and to, I think, a lot of other people who hire contractors, that you can only hire contractors for doing something that's not part of your routine business or your purpose as a company or an organization. And C, to treat the worker as a contractor, you have to show that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So basically, you have to show that the contractor has established themselves as a specialist or someone who does this kind of work, whatever that is, driving a truck and delivering packages or whatever the work may be. You have to show that this is an independent business of that contractor. Something that's so significant about the ABC test compared to older court rulings about who can be a contractor and who can be an employee is that under the ABC test, to treat someone as a contractor, the worker must meet all three, A, B, and C. Older court rulings that Hasmeet will talk about a little bit had a more sort of long-winded list of factors, and you didn't necessarily have to meet all of them, but most of them, and it was just a little bit more squishy before. The ABC test is really strict in that it sort of condensed it down to these 3 factors, and you have to meet all 3 factors to treat someone as a contractor. And the default assumption that the law makes is that someone is an employee. This is not maybe super brand new, but the default assumption is that someone doing work for a company should be an employee, and that if you want to hire them as a contractor instead, it's on the hiring entity, the business entity, to show that the nature of the relationship meets the ABC test. So this ruling really sort of shook the business community in California. So then what happened is that the legislature felt like they needed to respond to this because the ABC test was sort of so strict and extreme. And so that's how we get to AB5, which Hasmeet will talk about.
So, you know how the Dynomax case, the ruling was in, I believe in April of 2018, and the legislation decided what is the best way to incorporate this test that's so condensed and clear into codified into a statute. So California Assembly Bill 5 was introduced, I want to say in December of 2018, and they codified the landmark case, but what they also did, 2 important things. One is they expanded the enforcement by including different agencies into the bill, and they also placed the burden of proof on employers to show that the worker is classified as an independent contractor. So the Governor Newsom signed the bill on September 29, 2019, and it's called Section 2750.3 of the California Labor Code, and going into expansion of multi-jurisdictional enforcement. So previously, when there was a misclassification, right, there's a wage order, you follow the wage order, and oftentimes, you know, you go to the labor commissioner or you go to the local state Supreme Court, state superior court or county-specific superior court to file a claim. Now, with this legislation, not only the labor commissioner has jurisdiction and the court, but we have additional agencies such as the Employment Development Department, EDD, and that includes unemployment insurance, franchise tax board, the Attorney General, or even the city attorney if the city population is in excess of 750,000 people. The city attorney can actually intervene and sue the local business. And then there's also collective action, meaning some unions can actually have jurisdiction to file a lawsuit. This is huge because it really expands the jurisdictional agency of these enumerated agencies here. So,
I got a question.
yes.
So, is there any particular entity that is actually pushing this and lobbying for this more than anybody else?
My understanding, but a lot of labor unions were involved in passing these. Various advocates, workers' rights groups. Yeah.
So the motivation behind it is to protect the workers'
Yes.
rights?
Yes.
Okay.
Just because the precariousness of gig worker, that classification was becoming too obvious. Yeah.
It seems to me that the primary reason has been to protect the employees. But what's happening in my case is people who have been employees, they want to be contractors. They want to be, and they're paid a lot more. They don't get a car. They don't get various things that are paid for by the employees. Compensation. They get paid more as contractors. They're protected in that way.
Right.
They don't want to revert to being employees.
Yeah, so one of the, the state actually, in addition to the labor unions and other workers' rights groups, the state had a really compelling interest too because they wanted to make sure that their agencies are getting paid for, for what's owed. Their taxes are being paid, payroll taxes, unemployment insurance. So that's another reason why, because with Contractor you get 1099 and they have the burden of paying taxes, but they wanted to make sure that businesses are paying their fair share of taxes here too. Yeah. So AB5 presumption. Oh, looks like we have some new folks here. Welcome. Hi.
Traffic being as it is.
Okay.
We started a round of introductions since we have a relatively small group. If you would like, we are recording this presentation, but if any of you would like to just generally your name and where you're working or what brought you here, that would be great.
So my name's Monique Pavon, and my sister and brother will introduce themselves. We are looking into information on how we could possibly form a nonprofit and open up a group housing for people with special needs and disabilities.
Are you
For the legal.
got it. Okay. Cool. Okay. So they might go off and have a separate consultation. All right. So, with AB5, the presumption is that all workers are employees, meaning that they're entitled to the following, and there might be more depending on the policy with the employer. So minimum wage, workers' compensation, unemployment insurance, expense reimbursement, paid sick leave, paid family leave, and of course employers pay half of employee social security tax. So that's the presumption unless they depart from it and prove
that the person they're hiring services for is an independent contractor. So,
Yeah, and this is like just a really like basic level list of things that employers are responsible for their employees. Like some of you probably know that employers also have to provide employees have responsibilities to employees, such as to provide a safe working place and, you know, have to have numerous other kind of policies.
like ADA,
and,
of course, OSHA.
there's so this is sort of like the basics, but having employees comes with a great number of responsibilities, which is why so many people try to avoid complying with employment laws.
Yeah. And just to address your question, Stuart, okay? We're gonna go through carve-outs, exemptions, and there's specific professions where, this will not apply. Okay. So here we are, exemptions to AB 5. They're narrower than Dynomax, and by narrower, what we mean is Dynomax was broader in terms of its applicability. AB 5 actually has a number of carve-outs that the case itself didn't necessarily have, or it wasn't as expansive as AB 5. And we've identified 5 kind of general categories of exemptions. Number 1, Borrello test only exemptions, and we'll go through what's the Borrello test. Take it to the next slide. And then professional exemption, business-to-business exemption, construction industry subcontractors. We're not going to go over that one, just an exemption there, and other exemptions. So ABC test is a big deal because the prevailing law for quite some time, in fact, since 1989, was this case, Borrello and Sons versus DIR, also known as the Borrello test. And this is usually what gets used at the labor commissioner and in courts to examine whether the classification is accurate, whether someone is an employee, whether a worker is an employee or an independent contractor. And largely this has to do with right to control the workers. So it has to do with the involvement of the employer or alleged employer with the manner and means of accomplishing the result desired. In addition to some of the secondary factors, there are actually 11 factors, but the 4 listed here is pretty predominantly what gets addressed. So number 1, whether the worker is engaged in an occupation or business distinct from that of the principal, which is the employer. Number 2, whether or not the work is part of the regular business of the alleged employer. Number 3, whether the principal, again, employer, or the worker supplies the instrumentality, tools, and the place of the person doing the work. And 4, the worker's investment in the equipment or materials required by their task. So this is the test, and AB 5 incorporates this test in some of the exemptions that we're going to go through together. Have any questions so far?
Can I see the previous screen again?
Of course.
Very quickly.
So, first we're going to go through Borrello test exemptions.
And this is what used to be the main test.
This is what used to be the standard. So until now, the standard has changed to ABC test. Yeah, which is huge. Because Borrello test, there's just much more flexibility in terms of who was a worker, who was an employee and who's not. And I think ABC test, just like Christina said, you have to meet all A, B, and C, and it's not like a list of factors. So it's, the standard is higher now than it used to be.
So like in Borrello, you might not meet one of those or 2 of those, but you might still say, well, overall, the court might say overall you're still sufficiently independent and free enough to be a contractor.
When would it be appropriate to ask her a case example? Now or later?
Appropriate to ask.
Ask her like a case example to.
Let's go over the exemptions and then maybe you can tailor that. Yeah.
And also, if you want to discuss, like, your specific situation in more detail in a more confidential setting with an attorney, that might be available after this presentation, and Tia can kind of help, facilitate that. So it's up to you how much you wanna share here, or how much you might wanna, share in a.
Did you wanna bring up like a general case study or specifically tailored to you?
Well, it would be tailored to me, but I think could be of interest to other people.
Right, okay. Hold on that, yeah. Okay, so first, the Barella test only exemptions, and this is the list of Barella test only exemptions. Healthcare professionals, licensed lawyers, architects, engineers, security, et cetera, individuals licensed by the Department of Insurance, direct salespeople, real estate licenses, and certain commercial fishermen. So with this, as long as you meet the Barella test, you'll be exempt from AB5, which means exempt from the ABC test altogether. Now the standard,
So now do you still have to pass everything on the Barella test, or is it still the overall?
not everything is multi-factor, so I think predominantly if you pass it, then you will be high contractor. If not, especially with the right to control, then it would be exempt.
Even if you want to be status like.
So, yes, even if you. So now we're gonna increase the standard a bit more. Exemption for workers providing professional services. Now you may be asking, this prior slide also lists certain careers that are considered professional services, but for these ones, you only have to meet the Barella test. But you'll see a list. This is the list for professional services, and the standard for these fields, these careers, is different. So this is the standard. So in addition to satisfying the Barella test, you have to satisfy the following 6 factors. Who would like to read the 6 factors? Who would like to? Okay,
So, number 1, the individual must maintain a business location, which may include a personal residence that is separate from the hiring entity. Number 2, if the work is performed more than 6 months after the law goes into effect, the individual must have a business license. Number 3, the individual must be able to set or negotiate their own rates. Number 4, the individual must be able to set their own hours. Number 5, the individual must be customarily engaged in the same type of work performed under contract with another hiring entity or hold themselves out to potential.
Well, I'm sorry. Yes. Second.
Okay. I should have been able to do that. Okay, let me find my place. All right. Number 5, thank you. The individual must be customarily engaged in the same type of work performed under contract with another hiring entity or hold themselves out to potential customers for such work. And 6, the individual must customarily and regularly exercise discretion and judgment. That's pretty big.
Yeah, so this is the enumerated list of factors that you have to satisfy in addition to the Barella test to qualify to get an exemption for workers who provide professional services. And here is,
That's the way it is now, or that's the way it used to be?
that's the way it is going forward, starting
Going
this
forward.
year, January
Okay.
1st.
And you have to satisfy
You
all
have to
6.
satisfy, yes, all the 6 in addition to Barella.
What does 6 mean?
6 factors, sorry.
I mean, what does the 6th one mean?
Oh, sorry.
Okay.
Go ahead, go back. No, let's go. It just stopped sharing.
So you were saying, what was?
I was just curious about the last one.
Oh, number 6, I'm
Like,
sorry.
Yeah.
So the last one, the individual must customarily and regularly exercise discretion and judgment, meaning they're the ones who decide on a strategy and what type of work they want to engage in, discretion in making that decision, not someone else telling them how to
So
do
it's
it.
not determined by the employer.
and if you, when we get the slides back, there's a list of types of professionals who can use this new standard, and it includes a lot of like writers and designers and sort of people who usually have some, they might be working under a general like assignment from their client, but they often exercise some kind of like artistic or literary kind of judgment in their work.
Yeah, and there's a limit to that, though. It's 35 times per year.
Oh, wow.
And the reason there's that limit, in fact, one of the associations, artist associations, wrote a letter to the assembly. I don't know who. Maybe Newsom, maybe another elected official, basically saying you can't limit creative writers to provide work content for us 35 times per year. It should be more. You're restricting their work. But their response is that then you should hire them as employees. Yeah. Because we want to make sure that they have, number 5, they have, you're not dominating their work unless it's a big project, that they have other options and they get to be hired for their services with other businesses. So this is the list of workers providing professional services. Includes graphic designers, artists, enrolled agents, anyone that's licensed to be estheticians, electrologists, manicurists. That manicurist is until January 2022. Barbers and cosmetologists. Yes.
So this list of people is like a subset, like workers providing professional services is a subset of the people who get exemptions under AB 5. It's just that they have special other conditions.
Yeah, in addition to the Borrello test, they have to meet the same factors. Yeah.
And I know you guys wanted us to wait until later, but, sort of a specific situation for our agency is that we have tutors and folks who just come in part-time, maybe a couple hours a week, and some people a couple hours a month. But we pay them for their time. Would they not fall under this category? Because I don't see any of that up there, like tutors or...
Unless they have their own business, which is what we're going to talk about, business-to-business exemption.
Yeah, I think kind of a theme with all of these is they all sort of, they're all doing work that's like somewhat kind of creative, and it's a pretty kind of specific list of types of jobs, so I'm not sure I would advise like trying to kind of add, squeeze someone's job into here.
They're trying to get in theater workers, people in theater, to that list right now. But,
I would think that, excuse me, Jesse, but I would think if you had somebody like doing similar kinds of things with various people, there'll be more justification for them being independent.
and they have to provide, which will go into business-to-business exemption, which is what you're, I think, referencing to.
That might be most relevant to your situation too. Yeah, should we move on to the business-to-business exemption? Okay, so this is the last exemption that we're going to talk about. So you can also avoid the ABC test and kind of the sort of some of the criteria of the older Borrello test are sort of like incorporated into this business-to-business exemption. Like the first one, A, the independent contractor is free from the control and direction of the hiring entity. That's like a phrase maybe straight out of Borrello. And B, the independent contractor is providing services. So this one is unique, a kind of new thing in the business-to-business exemption. The independent contractor is providing services directly to the hiring entity rather than to customers of a hiring entity. And I think the legislature was thinking about, like, Uber-ness drivers here when they added this clause in this business-to-business exemption. You know, they didn't want, Uber to, kind of easily be able to use an exemption like this. So they said, well, you have to be doing work for the hiring entity, but you can't interact with somebody else's customers on their behalf. The contract for services is inviting. Hopefully, if you're hiring independent contractors, you are already using written contracts. It's generally a good idea, but now, to use this exemption, it has to be in writing. The independent contractor has a business license or business tax registration. This is something that probably a legitimate independent contractor should have had already under the old laws, but now it's being codified in the labor code as an express requirement. This only applies, some of this is directly copy-pasted from the new law. In a few cases, I shortened the language to make it a little bit simpler and easier to read on the screen here. So this one is actually only if the independent contractor is in a city, if their business is in a city or they're doing business in a city where there is such a requirement, which there is in most cities, but not every single city. Probably mostly in rural areas, you might not have a business license or a business tax registration, but in most cities in California, so you'll need a business tax, or the independent contractor will need a business tax. The independent contractor maintains their own business locations. There's quite a few more criteria here. Would anyone like to read the next F, G, and H criteria so that we're not listening to my voice too much?
I can read it.
Great.
F, the independent contractor is customarily engaged in an independently established business of the same nature as that involved in the work performed. G, the business service provider actually contracts with other businesses to provide the same or similar services and maintains a clientele without restrictions from the hiring entity. And H, the independent contractor advertises and holds itself out to the public as available to provide the same or similar services.
So these three sort of go together to basically say that if you're gonna hire an independent contractor under this business-to-business exemption, you can't hire them as like a full-time independent contractor, you know, 52 weeks out of the year, you know, week after week after week, et cetera, because they should, if they're a legitimate independent contractor, they should be putting themselves out there to do similar work for other clients, basically.
What if they're available 26 weeks a year, and they are doing other work, they do other things. So this is where it gets
That might be okay, if you know, 26 weeks out of the year they work for you, and 26 weeks out of the year they work for other clients.
Or 3 days a week, 2 or 3 days a week they work.
Yeah, under F, that might be okay if they're engaged in, you know, an established business of the same nature for other clients. Under G, they actually have contracts with other clients for similar work, and under H, they advertise, so they have a website or something that promotes their services. Sure, yeah.
Do businesses have to qualify for all of these to be?
Yeah.
Okay, so if a tutor from my tutoring co-op couldn't work for Galen under this, and tutor Galen's clients then, because that would violate.
Yeah, going back to, B, the independent contractor is providing services, directly to the hiring entity, so the contractor should not provide services to customers or clients of the.
I could train someone on their staff, but I couldn't tutor one of their students.
Exactly.
Is that what you do predominantly, is it tutoring? Logan, is it the organization?
It's one component. It's also, we also provide coaching and group work. Yeah. Now, what's the difference, if I may, and I don't know, just kind of throwing this way off, the difference between, paying someone a contract fee versus a stipend, honorarium or something like that?
Do you work for a nonprofit organization?
Yes.
Oh, okay, so nonprofits can get away with having volunteers pretty easily, as long as there are a few limitations around having volunteers in a nonprofit, but generally, nonprofits can make use of volunteers pretty freely. And that means the volunteer's not an employee, you don't have to pay them minimum wage, you don't even have to provide them with meal breaks if you don't want to, et cetera, et cetera.
We're nice to our volunteers.
Yeah. A lot of nonprofits try to do this thing where they offer a volunteer a stipend, which is usually some amount of money that's less than what it costs to pay someone minimum wage and to pay all the payroll taxes and things like that. I have a lot of nonprofit clients, and I usually discourage them from doing it because I worry that paying a stipend might make it look too much like you're basically just trying to evade employment law when you should be treating someone as an employee. And one of the limitations around having volunteers in a nonprofit is that you don't want to make the volunteers dependent on the organization they're volunteering for like their livelihood. Like they really should be volunteering. And so depending on like the size of the stipend and like how, the length of the duration in which they're receiving the stipend, I worry that it starts to look like you're just like not paying minimum wage to someone who should be.
Is there any preset hard ceilings
No.
around that?
Well, I think if it starts looking like you're depending on volunteers to run an organization, especially the operations of the organization, then that might get,
Yeah.
might get muddy.
So it's generally safe to offer perks to volunteers if you like feed them food, while they're on site volunteering, or provide little perks like that to them. It's totally fine. But if they're starting to sort of, rely on the stipend that you're paying them, then it sort of looks like, well, you're just avoiding employment law. So it's a little, a normal company should never do this stipend thing. You should. For a regular for-profit business, everyone should be a contractor or a business owner or an employee. But yeah, volunteers have this, or nonprofits have this flexibility to have volunteers. So, but yeah, there's no really like bright line, clear rules around stipends.
And because of the added agencies that are sort of looking at this now, does that mean that they're gonna be more aggressive?
Yes.
And sort of scanning?
Absolutely. Franchise tax board might intervene and say you're not paying taxes, or, EDD say you didn't pay unemployment insurance, but you had employees. Even the city attorney can intervene. Yeah, it's much broader.
Interns have a different classification as employees.
Interns should usually fall into the category of employee or volunteer or contractor, although under all these new rules around contractors, I have a very hard time imagining an intern being a legitimate contractor. But yeah, I would say the default rule should be that an intern should be treated as an employee unless you have some argument otherwise. In a nonprofit where they can have volunteers, you might commonly see interns being volunteers, and that's
Especially if they're getting,
usually okay.
Yeah, especially if they're getting credit for school. There's that kind of established relationship. Oh, it may not be established, but they're getting credit in exchange for their work. Otherwise, especially with for-profit businesses, it's, interns without paying them, it's a red flag for a violation.
And if you do pay them, it's like employees, they could be volunteers.
They can be interns, they can, their title is an intern, but they are an employee,
So believe it or not, we didn't actually get through the business-to-business exemptions. The criteria for this one is very long. It's much longer than ABC test, even though you're exempt from the ABC test. So we have one more. So we went all the way through H, and these three criteria were sort of about the contractor doing similar services for other customers or clients. And then I think we have one more. Yeah, we have one more slide of criteria for the business-to-business exemption. So, there's I, that the independent contractor provides its own tools, vehicles, and equipment, et cetera. So this is similar to the old, Borello test, which used to be sort of an optional factor, but it's kind of a required factor now in the business-to-business exemption. The independent contractor can negotiate its own rates. I think the legislature maybe was also thinking about Uber and Lyft drivers here, because there's usually standard rates set by Uber and Lyft or other gig economy tech platforms, and the legislature said, no, a true independent contractor can negotiate for its own, fees and rates. K, consistent with the nature of the work, the independent contractor can set its own hours and location of work. So I think the legislature is trying to say here, there may be times when an independent contractor needs to be at a particular place at a particular time to provide services to the client, but generally speaking, they set their own schedule. And L basically says the contractor is not a construction contractor, which is a whole separate ball of wax. You know, any kind of construction or landscaping work, falls under a different exemption, and those contractors need special licenses from the contractor state license board, so that's kind of outside of the business-to-business exemption, and like construction, repair, landscaping work. And that was the last of the exemptions, I think, right? Do we have one more slide?
I think so, yeah.
I sort of recapped some of the highlights of the business-to-business exemption here, since there's so many criteria. I sort of just summarized some of the ones I think are the most non-intuitive or the most different from sort of the older, contractor standards. So B, the contractors providing services directly to the hiring entity, not to customers of the customer. The independent contractor has a business license or a business tax registration, usually with their city government. Contractor maintains their own business location. In this one, it doesn't specify whether the business location can be your home. So, in one of the other ones, it says it can be your residence. In this one, it doesn't say. They maintain their business location, so that's something that I think will be fought over. The independent contractor is customarily engaged in an independently established business of the same nature, so doing similar work for other clients. And, F and G are sort of similar. They're, actually contracting with other businesses to provide the same or similar services. So these are some of the highlights. And then I think we have
The real estate licensees and repo agencies, they're actually governed by the California Business and Professions Code, not the Labor Code with this exemption. So, and then independent truck drivers.
I'm
We have a lot to say about that.
There was a lot of exemptions, and we kind of picked the ones that we thought were more broadly applicable. So just so you know, there could be other exemptions. Do you have a question,
I'm
Victoria?
just trying to understand, so the business-to-business exemptions are different from the professionals who provide services exemptions?
Yes.
That, like, if you're, like, from that list of professionals who provide services, like a graphic designer, for instance, like, is there wiggle room for them to choose which one of these exemptions it would be, or just it doesn't matter?
Yeah,
I suppose so.
Except, I think it's easier to meet the six factors
Than
versus
the
other one, yeah.
And then there was a whole other list of exemptions that are not these two, right? Or are these the only two?
There are professional exemptions like attorneys and architects and doctors, and they have sort of their own criteria.
So
Or they're actually the most broad exemption, is the borough.
So nothing changed for that?
Yeah.
ABC did not impact them.
So there's those 7, and then there's the professionals,
Yes.
and then there's the...
Yes.
Yeah, those seem to us like the most broadly applicable.
There's so many different tests, it can get really confusing.
And we expect that probably the legislature may have more legislation this year to kind of fine tune some of it. Because there's a lot of people who are still upset, even with all these exemptions, that it still doesn't give enough flexibility with the new ABC test. So I would pay attention to, further possible changes in some of this, or creation of new exemptions that don't exist yet.
And I think there's also the culture of working remotely, and that may just not be a factor as much as anymore, you know, because there's just like so much, used to be a heavy emphasis on that, but not anymore because that's part of the culture. A lot of people are employees and, work remotely, so there's that. Any questions?
Any questions on employment law that we didn't bring up about having employees more generally, or any of this?
I guess I was just wondering about the consequences of, like, if it turns out you are employing someone as a contractor, but then under this, they're not considered a contractor, like, what would be the consequences of that?
That's a great question, and
No, you should talk about this.
yeah, so labor compliance is a big practice area for me, and one thing that is common, for example, a yoga studio, right, they have teachers, and for quite some time, because they're flexible, and then, you know, there's a set schedule, there's some flexibility with teaching, and they come in just for that preset time and go and leave. I know a number of yoga studios that are changing their classification, and when someone brings up a labor dispute before they go to the labor commissioner, we've been suggesting, we're not providing you legal advice here, to enter into a good faith wage dispute resolution with the person and kind of close that part, but not link it with termination, just a good faith resolution on a labor dispute. And another thing too is to file an IRS reclassification, voluntary reclassification form that dates back 3 years. And you can talk to your accountant or tax attorney about that. Yeah. And you know, some of this is also unclear how these agencies are gonna, you know, communicate. Will they have like a standard portal of identifying these issues? Like, I don't know how that's gonna work, 'cause that's gonna increase bureaucracy even more in some way. Yeah.
And the purpose of filing the IRS reclassification form would be to...
It's basically you're paying 15%, it's usually 15% penalty on the prior, you know, hires.
Okay.
And, yeah, you're doing your good faith in reclassifying the workers.
Sure.
But you didn't necessarily have to do that locally, like statewide before, so I'm curious what correcting looks like with AB 5, and I don't know that yet.
Do you have any thoughts on, like, what if you don't take those kind of preventative care steps now and you continue to operate in violation of AB 5? What are the consequences? Then is that kind of like what you're...
I guess so, yeah, like, let's say, like, you have tried in good faith to, like, make sure that you're operating under this, but, like, either you made a mistake or, like, you just didn't do it in time, like, what is the,
So, the statute of limitation on labor issues is 4 years. So you can just, you know, whoever you hired 4 years ago likely will not be able to have a claim, but those people, let's say you hired 2 years ago, or the company hires 2 years ago, will have a claim, an open claim, and they can claim up to 4 years.
after the law goes into effect, so after this January.
Oh, I see what you're saying. Well, if they can argue under Borello, yes, but under ABC test, since it's effective this year, it would be just going back to this year, yeah. Because it's not retroactive, yeah.
Yeah, I mean, in general, for violating employment laws, there can be pretty significant consequences, especially for a small business or a small nonprofit organization. Like, one, a disgruntled worker can bring a civil action against the employer alleging, I should have been treated as an employee, but I wasn't, and you know, I should have been receiving blah, blah, blah benefits or additional wages or whatever I would have received, as an employee, and so they can, you know, seek to recover whatever amount of money or compensation that adds up to. Or it could come up if someone is fired and then, or has to be laid off for whatever reason, and then they try to apply for unemployment benefits from the state, but they're unable to get unemployment benefits from the state because they weren't actually an employee, and so then that can sort of give rise to a civil suit against the former workplace that, like, well, I'm unable to get unemployment benefits now, I should be able to get them, but my former workplace misclassified me, and so, you know, they can try and go after you for whatever unemployment benefits they think they're entitled to receive. There's also, if someone files a complaint with the state regulators, the state regulators can impose fines on an employer for not complying with employment laws. And as Nico was talking about earlier on in the presentation, there are more regulatory agencies that have power to bring actions now too. But yeah, I've seen some small businesses fine thousands of dollars for like what seem like really kind of trivial violations of employment law. So
I'm not really worried about any employees or contractors filing any action against me, and I'm not even clear that I violated. Like, what would trigger a governmental agency into
investigating?
Yeah.
They do sometimes do routine inspections of certain types of businesses. It's more common in the agricultural and food industries than other industries, I think. I believe I've maybe heard of random unannounced inspections on construction sites. This doesn't happen all the time, but I think I've heard of that sort of thing happening. Usually, though, it's more likely to be an issue if they get a complaint from a disgruntled worker or someone.
And you know, you do have to report usually with EDD how many employees you have, so they have things on record. And I don't know if they'll do like cross verification with franchise tax board, or to see you know, if it matches. Like, this is so new. I don't know how they're gonna monitor it.
It could also come to their attention if someone who gets laid off or fired even mistakenly believes that they were an employee and then tries to apply for unemployment benefits and then discovers they aren't eligible. Or it could also happen if there's like an injury on the job and someone thinks they should be entitled to workers' compensation insurance, because you have to have that for employees but not for your contractors. So that could also create some risk of some kind of a notice, you know, even if the worker didn't intentionally try to rat out their employer. I've also heard a colleague of mine being questioned when she went to the hospital one time about an injury, like, did this injury occur at work or not, because the health insurance company wants to go after the workers' comp insurance if they can recover against workers' comp. They don't, you know, your health insurance company will try and get out of paying for anything they can. So like these kinds of things can come up where like it's not like a disgruntled worker trying to get their workplace in trouble, but it kind of happens by other circumstances. Right. So we're just a few minutes over time. Actually, we timed this out well. Amazingly, I never stick to time limits like this. So thank you everyone for your questions.